The ASX Corporate Governance Council has also recommended that publicly listed companies disclose economic, environmental and social sustainability risks. This is a reflection on what's happening in the UK, because in the United Kingdom, they've actually changed the equivalent of our Corporations Act requirement that directors act in the best interests of the corporation. They've actually changed it with what they call the enlightened shareholder value principle. And this is where they actually go in to explain what is in the best interest of the company, and they require directors to have regard to longer term and various corporate social responsibility factors when making their decisions. A much more prescriptive approach than we adopt in our law. It's interesting that the Corporate Governance Council has picked that up in one of its corporate governance recommendations. Of course, the area of diversity always warrants some discussion, given, as said on the slide, the glacial progress that is happening there in relation to particular gender diversity on boards. In that context, though, it's worth noting that the ASX Corporate Governance Council has perhaps toughened up its disclosure requirements on the gender diversity issue by requiring more measurable goals to be disclosed by organisations. Also for organisations to have regard to the women in their senior executive ranks, as well as throughout the organisation. In terms of the disclosure, though, this is happening generally across the corporate Australia with the introduction of the requirements under the Workplace Gender Equality Act. These come in place in the next financial year, 2014 to 15, and for any employers with more than 100 employees, they will need to disclose against 6 gender equality indicators. And publicly listed companies will no doubt fall within that, and they can satisfy this requirement by disclosing against those indicators. But to give you a taste for some of those indicators, it requires companies to disclose the gender composition of their workforce by occupation, classification and employment status, to look not only at the gender composition of boards or their governing entities, but also go forward and do audits of the remuneration of men and women throughout their workforce who are performing comparable roles. Look at the employment conditions that are on offer, particularly in relation to flexible working arrangements, and also to disclose what kind of employee feedback or staff survey arrangements they have in place to get their employees' views on gender issues. So that's a factor that's really coming to the fore now. Briefly, some other new developments are in the area of bribery and corruption. And in this context, this is pertinent because our federal criminal code makes bribery a criminal offence. However, under the Australian provisions, what's commonly known as facilitation payments, they do not constitute an offence, provided that there is appropriate record keeping in relation to those and the benefit is of a minor nature. It's interesting that we always harken back to the Australian Wheat Board example, because there Mr. Lindbergh, who was the CEO of Australian Wheat Board, he admitted to improper business practices because as the managing director and CEO, he had approved some of the payments that were made. The court, when considering what penalty would be applied to Mr. Lindbergh, made the point that by not having appropriate systems in place and approving those payments, he had actually acted improperly and in breach of his common law duties. So that's hearkening back to the principles that were discussed earlier by Paul. And just when you thought, well, this isn't going to apply to me because I'm on the local footy club, we have to think about that again, because it's also going straight through to sporting organisations, and as we'll touch on in a moment, not-for-profit organisations as well. Interestingly, in relation to sporting organisations, where it's a national sporting organisation with more than $5 million worth of funding, the federal government is now putting in place certain requirements in relation to the governance of that organisation, which you can see there on your screen. Interestingly, they will now need to incorporate and become companies limited by guarantee. that would mean that they become public companies, and so the laws that apply to public companies, listed or unlisted, the ones that apply to unlisted public companies, would equally apply to them. And interestingly, the diversity issue is also gaining some precedence, requiring 40% female board representation by 2015. Conscious of time, I might just switch. Oh no, I can't go without mentioning my poor beloved Bombers. I am a long-suffering Essendon supporter, and that's why this slide is in here, because you will all recall the report that Switkowski undertook in relation to the governance arrangements with respect to Essendon and, as some people call them, the peptide boys. In that context, though, it's important that there were three of the recommendations Switkowski made, and one of them was to ensure that your organisation passes up bad news to the relevant executive and board level. And that was one of the concerns they had in relation to the Essendon Football Club, that the bad news was not seeing the light of day. Secondly, that the policies and procedures for the organisation are regularly reviewed and updated. And this is something boards need to ensure is done, and sometimes they have a direct hand in it, to sign off on the relevant policies and codes of conduct. And thirdly, whatever your organisation, ensuring that the key risk drivers, such as Paul identified earlier, are being reported through to the board. And in the case of the Essendon Football Club, that related to issues such as the attendance of players and ensuring that you get some of those players and members of the leadership group attending board meetings so you can get some visibility on some of the key issues affecting the club. I mentioned earlier in relation to the not-for-profit area and how some of the governance issues are now applying in relation to not-for-profits and charities, particularly with the onset of, the introduction of the Australian Charities and Not-for-Profit Commission. Now, whilst it's still a little bit up in the air as to what's going to happen with the Commission with the new coalition government, it is still in effect. And those of you that are directors of not-for-profit organisations will be familiar with the reporting requirements that have now been introduced, particularly in relation to charities. Significantly, charities will now need to provide statements to the Australian ACNC and must comply with certain governance standards. So that's when I said earlier, we all thought that it wasn't going to apply to us because we're just a local charity. Well, that's not the case. Some of those governance standards are set out on your slide, and significantly, it's important for not-for-profits and charities to be able to demonstrate that they have a purpose, and what is their purpose and what's their character. Now, a common way of doing that is through websites or publications to their members. But it's also important that they're quite transparent to their membership or members base as to how they comply with those purposes. That comes into them being accountable to members. Not-for-profits and charities need to establish some mechanism where there is some accountability back to their membership base. Commonly that's done in the corporate sector through an AGM, an annual general meeting. Many not-for-profits that are public companies limited by guarantee will have annual general meetings, but there may be others that do not, and this is one requirement that the ACNC has now instituted. Interestingly, there is also a requirement that not-for-profits and charities must not act in conduct that creates an offence. The reason why I emphasise that is it's actually saying you must not engage in conduct that creates an offence, rather than you must not create an offence. So that's allowing circumstances where an example that is used by the ACNC is if they suspect something untoward is happening within the organisation, they can act preemptively. A common example which is used by the ACNC is where they suspect there is fraud. So it entitles the ACNC to then impose itself within that organisation. Fourthly, it's important for organisations to ensure that the people that are running them, and this you can read here, this is usually directors or trustees, are qualified to be able to run them. That means that they're not disqualified, so they're not bankrupts or any other criteria that may apply. That requires a proactive stance by boards to ask individual members to update them annually, semi-annually, whether there's been any circumstances that would cause the members of the board to become disqualified. And finally, you've got the duties of what we call their responsible entities, and you can read in that that's really the trustees or the directors of the organisation. And those duties are very similar to the duties Paul outlined earlier. So if you thought that directors' duties didn't apply to you because you were for a not-for-profit or a charity that may not be incorporated, that's no longer the case. In the context of an update, it wouldn't be an update without mentioning tax. And as some of you may be aware, there have been changes to the tax laws to provide for personal liability to directors in relation to unpaid superannuation. In this instance, it applies very similar to the requirements where directors may be liable if there's been unpaid PAYG tax. And how it operates is that the ATO will issue a penalty notice to a director if it believes that there has been unpaid superannuation or income tax liabilities by the organisation for which they are a director. And the director has 21 days in which to respond. And the director can respond by ensuring the payment is made by the company, or if that's inappropriate, ensuring that the company, or voting with other directors presumably, that the company is placed into administration. What's important in relation to that 21-day requirement is that the ATO will have regard to the director's details that are held with ASIC. So one of the key things I say to the directors I talk with is, please ensure that your ASIC details are current, because if you have incorrect address details on ASIC and something like this should be sent to you, that 21 days could easily lapse without you even knowing it. Secondly, though, and perhaps more pertinent, importantly, is to ensure that you've got some mechanism within your board that you know that these payments are being made on a regular basis. Whether some organisations, I know in the not-for-profit sector, get their CFOs to certify to the board at every board meeting that the income tax liabilities and superannuation liabilities of the organisation have been satisfied. Finally, just moving now to some housekeeping matters. We always think about housekeeping and have a bit of a yawn, but it can bite us when we least expect it. And one of my favourite instances of this, as an old company secretary, is the Weinstock case that came out last year. Poor old Mr. Weinstock, he was the director of a family-owned company. It's a private business, and he wanted to appoint his wife as a fellow director. Prior to then, he was the sole director. He sought to appoint his wife as a fellow director, but it became apparent that his directorship had in fact lapsed, because under the terms of the Constitution, it had the rotation provisions provided that his directorship had automatically lapsed, and he had not, within that time period, appointed a replacement director. I'm not quite sure why ASIC took it upon itself to take issue with this, but they did, and claimed that the company needed to be wound up because it effectively was rudderless. It had no director. Mr. Weinstock was no longer a valid director because under the terms of the Constitution, and he could not appoint another director in those circumstances. Well, this matter ended up in the High Court, and fortunately the High Court used some of the discretions under the Corporations Act to provide some rectification for Mr. Weinstock so that the situation could be resolved. But the lesson here is, who wants to end up in the High Court because we've acted unwittingly in breach of some constitutional provisions? It's a very expensive process, and here it was an uncertain remedy, because to get to the High Court he had to go through the appellate process throughout the New South Wales court system first. So the lesson here, as at the bottom of the slide, is always check the fine print. Be wary of what's in your constitutions, and if you're not happy with what's in your constitutions as a board, don't be afraid to have it changed.